most people want to know if they're going to lose their license based upon the accusation of a DUI. And that's a really complicated question. There's two opportunities for you to lose your license. First, at the driver's license hearing. Second, if you're actually convicted of a DUI. The driver's license hearing is the first opportunity for the state to take your license away. In order to get a driver's license hearing, you have to request that hearing within 10 days. At the driver's license hearing, the state will be required to prove that the arresting officer had reasonable suspicion that you were actually in violation of the DUI law. If the state doesn't prove that because the officer doesn't show up, the officer hasn't done his job right, or they simply don't have the evidence they need, which would include a breath test, a blood test, a driving pattern, or anything else that indicates that you're DUI, then they cannot suspend your license at the administrative level. But they could still suspend your license based upon a conviction for DUI. This is why it's critical that you not be convicted of a DUI. Even if you save your license at the administrative level, if you're then convicted of a DUI, you're going to lose it for 120 days on the first offense, for longer for subsequent offenses. Now, the other thing that you need to know about the driver's license is if you refuse the chemical test, whether it's a breath test, a blood test, or a urine test, you're going to lose your license for longer at the administrative level. But you won't lose your license for longer if you're convicted of a DUI. Obviously, the trade-off here is that it's easier to convict you if you've got a chemical test, but they'll take your license for longer. So what I recommend to everybody is submit to that test. It's easier for us to beat a breath test than it is to actually beat a refusal. Submit to the test.